everyone, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Today's topic, should I avoid probate? The question on whether to avoid probate or not is a very client-specific question. Each and every person's situation is different. That's why creating an estate plan is so important. You should create a plan that is tailored to you, your family, your goals, and your assets. I don't specifically take the approach that everyone has to avoid probate. I think it's a good idea, but I take the approach that I'd like to educate you about what probate actually is and how you can avoid it. Then you can make an educated and informed decision on what is best for you and your specific situation. Probate is a court process. As such, there are a couple of key points to consider about whether or not you may want to avoid it. It is important to realize for probate, everything is filed with the clerk of court and becomes public record, which means things that you may wish to be kept private, such as who you're leaving your assets to and what you're leaving them, becomes public record. This can result in beneficiaries being subject to scammers who search court records to find targets who have inheritance on the way. So if you want to keep your affairs private, what your estate plan looks like and who you're providing for, then you want to avoid probate. As you might expect, since probate is a court process, there are going to be delays and it could just take a while to get assets through the court process to your heirs or beneficiaries. The length of the probate process depends on a number of things, whether you have an estate plan or not, the complexity of the situation, the assets going through probate, and whether or not the clerk of court is backed up. For example, generally the minimum length for probate is around 6 months. The typical length is about a year to a year and a half, and the longest probate our firm has assisted with was 3 years. So if you decide you want to make sure your family can act quickly and efficiently on your behalf and doesn't have to go through court first, then you want to avoid probate. Also, I want to emphasize that a will does not avoid probate. A will has to be filed with the clerk of court after one has passed away. Your assets will go through probate whether you die with or without a will. The difference is, if you die without a will, the court and the state statutes decide who your heirs are and the amounts that go to them, which may not be what you would have wanted. If you die with a will, you decide who you want to leave your assets to and the amounts that go to them. If you decide probate and the fact that it's public and can take a long time is important to avoid, then I would recommend that you utilize a revocable living trust as part of your estate plan. A fully funded revocable living trust is the only foolproof way to avoid probate, but that's a topic for another video. That's it for today. I hope you liked this video and found it helpful. Please share with anyone you think needs to hear it. Again, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Have a great day.